hearing in the appeal seen on the application of Smith against the Secretary of State for Defence and another.
Yes, Mr. Eadie.
My lords, my lady, good afternoon. I appear on behalf of the appellant with Mr. Saini and Ms. Moore. The respondent is represented by Ms. Rose and Ms. Seymour, and the Equality and Human Rights Commission are represented by Mr. Beloff, Mr. Hussain and Ms. Prekoshka. My lords, my lady, we are in Iraq in 2003, and this case arises out of the tragic death of Private Smith. He joined the Territorial Army in October 2002. Towards the end of May 2003 and into June 2003, he was undertook some pre-mobilization training. Then in June 2003, he was mobilized for service in Iraq. He arrived in Iraq on the 17th of June 2003 to Camp Eagle, which was in Kuwait, in the Kuwaiti desert, where he acclimatized for 10 days. He was then deployed on the 28th of June 2003 to Iraq, into a stadium, a sports stadium in the city of Basra. Between the 29th of July and the 12th of August, there are a number of occasions on which he reported as having had difficulty with the heat. On the 12th of August 2003, he was deployed to guard a power station and had some 6 hours of rest in an air-conditioned room, but otherwise was exposed to the elements. On the 13th of August of that year, during the night, he was conducting various duties, and those continued into the day, with at least some break in an air-conditioned environment, but otherwise again exposed to the elements. And obviously, given that it was summer in Iraq, the temperatures were extraordinarily high, sometimes over 50 degrees centigrade. At 6 o'clock or thereabouts on that day, that is the 13th of August, he was found lying face down outside the dining room of the stadium. A company medic was called, and then an ambulance was called. He was transferred by ambulance from the stadium to another camp called Abu Naji camp, and tragically at 20:10 hours that day, that is the 13th of August, he died. His death was the subject of various investigations and proceedings thereafter, including in particular what's called a learning account produced by his own unit. That was dated the 4th of October 2003 and can be found in Appendix 3, Bundle 1, at pages 164 to 169. An addendum to that report was then produced in November of that year. That's in the same volume, Appendix 3, Volume 1, at pages 266 to 269. There was, it's not entirely clear on what date, but there was a criminal investigation conducted by the Special Investigations Branch of the Royal Military Police, and a summary record of their investigations is in a record of events, which is in Appendix 1, Bundle 2, Tab 27, pages 315 to 320. There was then a Board of Inquiry convened. It was convened on the 24th of January 2004. That's to be found at the beginning of Appendix 3, Bundle 1. Its findings were presented on the 24th of May 2004. They were reviewed by headquarters, in effect, and headquarters decided that more needed to be looked at, including in particular what had occurred before he was sent out to Iraq in the United Kingdom. A second Board of Inquiry was accordingly convened, and that started to sit on the 22nd of June 2004. Its report, its findings were presented on the 23rd of October 2004, and its report is to be found at Appendix 3, Bundle 2.
Is there anything significant in the sentence that appears in the Statement of Facts that these are matters of record? Obviously, you can see the printed page and you can read what they say, but is there some other...
My Lord, I don't think so. I don't think that, unless someone tells me differently, there's no special significance. I noted that that had been used on a number of occasions, but I don't think with any particular intent to convey specialist meaning. Simply, it's on the page. And then, of course, there was an inquest between the 6th of October 2006 and the 10th of November 2006. And there is to be a fresh inquest, as my lords will have seen. That is the chronology. It has led to the two issues that you see at the end of the statement of facts, namely whether a soldier on military service in Iraq is subject to the jurisdiction of the UK within the meaning of Article 1 of the ECHR, so as to benefit from the rights guaranteed by the Human Rights Act while operating in Iraq, and secondly, whether the fresh inquest into Private Smith's death must conform with the procedural obligation implied into Article 2 of the Convention.
Mr. Reedy, Private Smith was in the Territorial Army. When he was sent out, were there any particular kinds of duties he was going to be doing, or was he just, does one differentiate between the kinds of duties he would be doing as a territorial and those which would be done by
well, as I understand it, not. They simply became part of the regular units and transferred as and where the need arose. That certainly appears to be the impression that one derives from the record of the inquest. Both of those issues, as my lords and my lady will have seen, are to some extent hypothetical, quite a large extent hypothetical, because it has been conceded by the Secretary of State that Private Smith was within the jurisdiction, and it has also been conceded by the Secretary of State that he will not make any submissions on the inquest to the effect that the scope of the inquest should be narrowed by reference to the distinction between Article 2 and not.
It does not matter, but what about the terms of service? The terms of service of a territorial soldier. I mean, he joins as a volunteer, obviously, to serve in the Territorial Army, but is he under a condition that if asked he will go to an operational theatre?
My Lord, I will double check that. I think the position is that if he's joined the Territorial Army, he does become subject to, as it were, compulsory call-up.
I believe that whether that's right or not is a matter of military law, that all territorial army soldiers in Iraq have volunteered specifically for that.
I will double check the status specifically. So that
it would be interesting to know whether Private Smith did actually volunteer or whether he was ordered to go.
I will make sure that that's checked, if I may.
Thank you.
Don't know the answer.
I'm just really on the question as to whether the second issue is academic. As you know, the respondent, paragraph 129, page 50, says not because whatever you may agree as to the scope of the inquest, and certainly there's no question of inhibiting the coroner and deciding how wide-ranging his inquiry should be. The suggestion is, and it may be right, may it not, that actually you can't consent to a, using the language of the case law, a Middleton inquiry, if actually the law dictates it's a Jameson inquiry in terms of the actual result.
My Lord, yes, we are very quickly, unless we're careful, straight into issue 2 and Hurst, where I know my Lord expressed certain...
Well, I know, but all I'm saying is, it doesn't therefore look academic.
Well, my Lord, I will make my submissions on issue 2 in a moment. I don't hang anything on the fact that it's academic. No. We're here and we're going to have the argument of principle we're going to have. The only reason for describing it as academic was in the limited sense that I indicated, namely that you will have seen the record in the Court of Appeal's judgment of the concession such as it was from the Secretary of State, which was linked to scope, my Lord is right to note, rather than inquisition, which I know is a topic of some interest when one comes to issue 2, that difference between scope and inquisition.
The first point may not be academic either, mate, because of the movement into and out of base. If one were only concerned with what happened in the base, which is where the death occurred, then one might have to have a rather, I think the other side would submit, awkward distinction of responsibility according to whether things were happening in the base or out of them. Isn't that possible?
Oh, well, it is possible. Again, I'm going to come to that issue because it rather depends why one's asking the in-base, out-of-base question. And that sounds both, potentially at least, in relation to the scope of the inquest itself, are matters that are out of base outside a Middleton inquest. And I'll be submitting that they're not, effectively, so there's not a lot that turns on that. But it sounds also, at least potentially, in the cause of action sense. If there is a positive obligation, to what extent does it matter for the purpose of that cause of action? Is the test that one deploys, for example, a predominant cause test or something of that kind? But it sounds potentially in both of those aspects. Yes. So I fully accept that there are complications that arise as a result of the in-base or out-of-base. The extent of them we may have to explore in a little while. And Lord, my lady, I was going to start, if I may, with the juror.
Private Smith died, obviously, in Iraq. His body was brought back to this country.
Yes, it was.
And that, as I would understand, would have triggered a requirement for an inquest. Yeah. Had that not been so, if his body hadn't been, I know that it is now the practice, would there be a requirement for an inquest?
Well, my Lord, there certainly wouldn't be a requirement for an inquest, as I understand it, under the Coroner's Act, because the jurisdiction that coroners exercise is dependent upon the physical presence of the body within the jurisdiction here.
Yeah, so there wouldn't be an inquest, so it would be some other form of inquiry.
My Lord, there would be a board of inquiry and a criminal investigation and the other strands, but the inquest would not be one of them, as I understand it, because under the 1988 Act, which I'm afraid, through some oversight, did not make it into your bundles, but is in the back of the white and rather threatening-looking new file that you have beside you. It appears that the jurisdiction is limited to the body physically being here.
And that applies whether it's a Middleton or a Jameson inquiry.
Yes.
But of course that doesn't affect the scope of the obligation under Article 2. And so if that obligation applies, well then some other means that an inquest would have to be devised for doing it.
You would be very subject to the custody healthcare distinction, which I'm going to come to. You would be in the situation you were in L, where there was no inquest, because although there'd been a near death, the person hadn't died. So one was, as it were, having to comply with the Article 2 obligation without the usual mechanism. My lady is right.
So your position would be that, as I understand it, would you concede, or you would have conceded in this case that there would have had to be an inquiry, even if the body hadn't been brought back?
There would have been some investigation.
Because it would have to be some sort of, because he would have been within the jurisdiction?
My Lord, yes, he would have been within the jurisdiction. That's the concession that's been made.
Yes. Whereas if the death had occurred outside the camp, then you would have said no. Is that just as I get clear in my mind? Yeah.
That's it. As I should have explained at the outset, I mentioned the threatening white bundle, and staggering though it may be thought that even though you have 17 bundles before you already, an 18th is necessary. I'm hoping we won't need to go to many of them too frequently. But the real purpose of it was to plug gaps, as it were. It contains, for example, the relevant provisions of the Coroners Act 1988 and the rules, which may be of some importance. It contains a couple of translations of authorities that are in the bundles that are only in French in the bundles. I think the person who put together the bundles assumed that all of my lords and my lady would be entirely fluent in French. That wasn't necessarily something which applied to all of us, so we've had them translated. Those are the two at tabs 8 and 9 in the white bundle. There were some copying difficulties, and so we've corrected those. And we've also included in there a copy of Al-Skani in the Divisional Court and in the Court of Appeal. The Divisional Court in Al-Skani is useful, at least to this extent, because it does provide a very helpful and comprehensive description of the legal regime which was operating at the time which concerns us, namely June 2003, which was very similar to the times that were in issue there. So, for example, that it indicates precisely on what basis the British forces were operating in Iraq at that time, so of some interest there. And we've also included Al-Sadoun in the United Kingdom, where a judgment on the merits, there had earlier been a judgment on admissibility, which is principally relevant to jurisdiction, but the judgment on the merits came out on I think the 4th of March or thereabouts, 2nd of March, was it? And that is of at least some passing interest for what it says about, in particular, about clashes between international obligations. So that's the white bundle. Then to jurisdiction, if I may. The first point that we would invite you to note in relation to jurisdiction is that the approach that should be taken by this court, we respectfully submit, is and should be a cautious one. There are particular reasons, we submit, for adopting a cautious approach to Article 1. And if I could invite you to take up the Al-Skani decision in the House of Lords, which is in Bundle 2 at tab 21. And turn, if you would, please, to paragraph 107 in the speech of Lord Brown.
Sorry,
107.
well, go on. No, but I mean, my tab 21 starts at paragraph 147, and I flick through, and it goes all over the place.
Yeah. It was no more and no less, or no less and no more. Is that what you're going to?
No.
No, but I mean,
I will come to that in a moment, I'm sure.
I mean, I start.
The pages are all in bizarre order.
The back page, you know, the back page, if you ignore the first page, I'm told by my junior, it may be that.
What's the last?
Maybe if I tear the first page out.
If you tear the first page out, does that make more sense? Yeah, try that.
No.
May just be that the last page has been copied twice.
No, my pages go in reverse order.
I'm missing Lord Brown's valuable words on the last page.
God, there's not a sign of things to come.
My Lord, it may not be very, this is perhaps the worst possible authority on which to have this sort of issue, because, as my Lords and my Lady will have appreciated, this is the leading authority on jurisdiction. We're going to be, I'm afraid, dipping in and out of it. So, for those who have got terrible trouble, I'm sure we can find some unmarked copies to replace. I don't know.
What paragraph is it you require?
107 was the one I was after.
Okay. I've got that. So I mean, I only need one page, so I can get that.
Thank you. Well, and we have got.
I'm okay with that one missing.
How many have you got?
I don't know whether Lord Mance is in. Well, can I offer that?
Yeah, please. Yes.
That's it.
James, here's an unmarked copy.
We've got another one helpfully provided by Miss Simon.
No, it's unmarked, that one.
I think that's unmarked too, I'm hoping.
No.
Is everyone else all right?
I have the good fortune to have a complete.
Simon?
So have I.
I could.
Well, I'm grateful. 107 was the one I was on. I was on a cautious approach. The Lord Brown says, Your Lordships accordingly ought not to construe Article 1 as reaching any further than the existing Strasbourg jurisprudence clearly, I emphasise clearly shows it to reach. And there were a variety of reasons for emphasising that. In other words, the need not to exceed that which the Strasbourg jurisprudence clearly indicates as the proper scope for jurisdiction. And those were analysed by Lord Brown in particular in the preceding paragraphs, 105 and 106. Perhaps rather than reading them out, I'm very happy to read them out, but if you prefer to read those two paragraphs yourselves.
Well, why don't you read them out? Because there are others who may be interested.
105. The ultimate decision upon this question, which must necessarily be for the European Court of Human Rights. Lord Bingham observed in Ulla, the Convention is an international instrument, the correct interpretation of which can be authoritatively expanded only by the Strasbourg Court. In the same paragraph, Lord Bingham made two further points. First, that a national court should not, without strong reason, dilute or weaken the effect of the Strasbourg case law. Secondly, that whilst member states can, of course, legislate so as to provide for rights more generous than those guaranteed by the Convention, national courts should not interpret the Convention to achieve this. The Convention must bear the same meaning for all states party to it. Paragraph 20 ends, the duty of national courts is to keep pace with Strasbourg jurisprudence as it evolves over time, and where Lord Mance said we were going to be sooner rather than later, no more but certainly no less. I would respectfully suggest that last sentence could as well have ended no less but certainly no more. There seems to me indeed a greater danger in the national court construing the Convention too generously in favour of an applicant than in construing it too narrowly. In the former event, the mistake will necessarily stand. the member state cannot itself go to Strasbourg to have it corrected. In the latter event, however, where convention rights have been denied by too narrow a construction, the aggrieved individual can have the decision corrected in Strasbourg. So, my lords, one sees from those two paragraphs perhaps three particular reasons for exercising caution when coming to analyse jurisdictional issues. Firstly, the convention must bear the same meaning for all states party to it. So the court should be very cautious before interpreting the convention to provide an expansive approach to rights, no less but certainly no more, as Lord Brown put it. Secondly, there is a particular and greater danger in the court construing the ECHR too generously in favour of an applicant than in doing so too narrowly. That is because the applicant, but not the state, can then go to the European Court of Human Rights to see if the judgment and reasoning was correct. So if, for example, it were to be decided in this case that there is a principle of personal jurisdiction of the kind found by the Court of Appeal, the government could not challenge that in Strasbourg. And thirdly, that applies to ECHR rights generally, but the position is a fortiori. The second applies to ECHR rights generally, but the position is a fortiori because of the nature of the provision being construed. It determines the very reach of the convention, as the quote from Bankovich that I didn't read out, but which is at the end of paragraph 106 in Lord Brown's speech indicates. To similar effect is the speech of Baroness Hale at paragraph 91, where she said, "The Strasbourg case law is quite plain that liability for acts taking effect or taking place outside the territory of a member state is exceptional and requires special justification. This court should not extend the liability of one member state, thus necessarily expecting other member states would do the same, unless it is," and I emphasise these words, "quite clear that Strasbourg would require this of us. I agree with my noble and learned friends that there is more to be learned from the decision of the Grand Chamber in Bankovich than there is from the case of Issa. Bankovich does not lead me to the conclusion that Strasbourg would," and I emphasise this word, "inevitably hold that the deceased, other than Mr. Musa, were within the jurisdiction of the United Kingdom when they met their deaths." So the cautious approach finds expression in the tests of clarity and inevitability in the two speeches that I've referred you to. And the hurdle to be surmounted by the claimant is, in my respectful submission, therefore, thus a substantial one. And for compelling reasons of principle, it might be thought. The question is, therefore, in the present context, is it inevitable that the European Court of Human Rights would determine that soldiers of any member state, and we would interpose, for reasons I'll come to in a moment, potentially the wider groups that form part of the Court of Appeal's reasoning chain, for example, diplomatic agents or others who might be subject to personal jurisdiction, is it inevitable that the ECHR would determine that soldiers are within the jurisdiction in all circumstances, wherever they may be in the world? And on one view, there is a relatively short answer to that. First, there is no case in which the European Court has so held. Second, and therefore, the argument depends on the creation by analogy of a further exception to the fundamental approach of territoriality. And we therefore submit that unless it is clear at the end of all the debate that the European Court would so find, the proper and correct approach in principle is the cautious one indicated in Al-Skani. Turning then to the substance of the argument, I start, if I may, with three preliminary points on the jurisdictional issues. Firstly, the convention for this purpose, that is for the purpose of construing the jurisdictional provision in Article 1, is not a living instrument, as it is in relation to all the substantive rights and obligations that appear under it. As Lord Roger noted in the Al-Skani case, at paragraph 69, the European Court of Human Rights specifically rejected that argument in the Bankovic case. You will see the relevant passage features on page 199 of the report, paragraph 69, between the letters A and B, where Lord Rogers says, in considering the European Court's approach to jurisdiction in Bankovic, it may moreover be relevant to recall that in Bankovic, the Court rejected the argument that the living instrument approach to interpretation of the Convention should be applied to Article 1. To the same effect, see Lord Brown at paragraph 128. And the relevant passage in paragraph 128 appears just by the letter H on page 214, where Lord Brown says, paragraphs 64 and 65 of Bankovic, I may note, contrast on the one hand the Convention's substantive provisions and the competence of the Convention organs, to both of which the living instrument approach applies, and on the other hand, the scope of Article 1, the scope and reach of the entire Convention, to which it does not. So the concept of within the jurisdiction is not a fluid one that is capable of developing and expanding over time. Put another way, it is as narrow as it was when the framers of the Convention in 1950 were discussing on what terms they were prepared to be bound by its provisions. And that first preliminary point, not a living instrument, is of importance because, both in its own right, but also because it feeds into the importance of the travaux préparatoire, which is my second preliminary point. The travaux préparatoire, a legitimate aid under the Vienna Convention on the Interpretation of Treaties, a legitimate aid to the interpretation of treaties such as the ECHR, as the Court recognised in Bankovic, are, in this instance, compelling. My Lords, you will see the relevant provisions of the travaux set out in the Bankovic, perhaps most conveniently in the Bankovic case itself. If you leave open Alskany, because we'll be dipping in and out of that if we may, Bankovic is at bundle 5 of the authorities at tab 47. The relevant paragraphs for this purpose in the judgment of the Grand Chamber are paragraphs 19 to 21, bundle 5, tab 47.
Admissibility?
Admissibility. It was only an admissibility decision because it was a question of jurisdiction. Right. Bankovic novels against Belgium, relevant paragraphs 19 to 21, and the reasoning at paragraph 63. Paragraph 19 says, the text prepared by the Committee of the Consultative Assembly of the Council of Europe on legal and administrative questions provided in what became Article 1 of the Convention that, quote, the Member States shall undertake to ensure to all persons residing within their territories the rights. The expert intergovernmental committee, which considered the Consultative Assembly's draft, decided to replace the reference to all persons residing within their territories with a reference to persons within their jurisdiction. The reasons were noted in the following extract from the collected edition of the Travaux Préparatoire. Quote, the Assembly draft had extended the benefits of the Convention to all persons residing within the territories of the signatory states. It seemed to the committee that the term residing might be considered too restrictive. It was felt that there were good grounds for extending the benefits of the Convention to all persons in the territories of the signatory states, even those who could not be considered as residing there in the legal sense of the word. The committee therefore replaced the term residing by the words within their jurisdiction, which are also contained in Article 2 of the draft covenant of the United Nations Commission. The next relevant comment prior to the adoption of Article 1 of the Convention made by the Belgian representative during the plenary sitting of the Consultative Assembly was to the effect that henceforth the right of protection by our states by virtue of a formal clause of the Convention may be exercised with full force and without any differentiation or distinction in favour of individuals of whatever nationality who are on the territory of any one of our states may have had reason to complain that their rights have been violated. The Travaux Préparatoires go on to note the wording of Article 1, including within their jurisdiction, did not give rise to any further discussion, and the text as it was and is now was adopted by the Consultative Assembly on the 25th of August 1950 without further amendment. And the European Court comes back to that feature at paragraph 63, as I indicated, in their reasoning, where they say, finally, the Court finds clear confirmation for this essentially territorial notion of jurisdiction in the Travaux, which demonstrate that the expert intergovernmental committee replaced the words all persons residing within their territories with a reference to persons within their jurisdiction, with a view to expanding the Convention's application to others who may not reside in a legal sense, but who are nevertheless on the territory of the contracting state.
It's slightly paradoxical. If the original wording had remained, all persons residing within the territories, it might have been easier to argue that Private Smith was such a person even when he was abroad.
Well, yes, quite perhaps. My lord, it's also to be noted that in relation to this part of it, that the European Court of Human Rights did not perhaps go as far as it might be thought it could have done on the basis simply of those travaux, because it was prepared to accept that there were certain exceptions to the essentially territorial notion of jurisdiction. So one doesn't go, as it were, the whole hog with that quote, but it is nevertheless important as indicating that the notion of essentially territorial does indeed mean precisely that, and that the exceptions, if they exist, should properly be tightly confined.
So your point is that while the word has been expanded by the word primary, whatever, the categories of exceptions are closed? Is that what it comes to?
Categories of exceptions are properly narrow.
Narrow.
We submit.
So there could be some enlargement by analogy, could there?
There could be some enlargement by analogy, as indeed occurred in Alskany itself.
But only by way of identifying precisely what was agreed when the convention was originally concluded.
Yes. But so it is possible. I'm not closing the door to possible analogies. The submission is the rather gentler one, which is that if you are going to do it by way of analogy, it has to be tightly confined. It isn't. It's a very large jump to say from a notion which is essentially territorial. Actually, it's an authority and control, pure and simple, or it's a personal jurisdiction. That is a very considerable leap. So if there are to be exceptions, they are to be narrowly confined. Is the submission.
What was the extension in Alskany?
The extension by way of concession in Alskany was...
Concession, yes.
Yes.
Well,
it was accepted by Lord Brown as being an appropriate and proper concession. Yes. And my Lord will, I'm sure, remember that there was a difference of view between the Divisional Court, which accepted the concession on a particular relatively narrow basis, and the Court of Appeal, which said, no, actually the true basis on which he fell within the jurisdiction is a rather broader one, based on a personal jurisdiction of control and authority over the individual. And it was that issue that essentially divided the parties, as I understand it, from the argument and the decisions below when the matter reached your Lordship's house.
But Strasbourg recognised effective control as the basis of jurisdiction.
Has Strasbourg recognised?
In Bagovich, it recognised effective control of the territory outside the territory of the national state.
Yes, it did. Yes, it did. And there was a separate issue in relation to that, as my Lord will remember, because the question that arose in that respect was whether or not that doctrine of effective control of the territory applied outside the espace juridique. In other words, outside that territory covered by states that were signed up to the European Convention on Human Rights. And the answer that was given by my Lordship, your Lordship's House, was no. It didn't extend beyond that. That was one of the core pieces of reasoning.
Are you going to come back to Bankovich? I mean, it's just worth reading the first two sentences of paragraph 62, isn't it?
Lord, yes. With its specific reference to military operations and including in the Gulf. I can't remember whether I was going to come back to that. I think I probably was. But it's there anyway. For those who are listening, those sentences state, the court finds state practice in the application of the Convention since its ratification to be indicative of a lack of any apprehension on the part of the contracting states of their extraterritorial responsibility in context similar to the present case. Although there have been a number of military missions involving contracting states acting extraterritorially since their ratification of the Convention, inter alia, in the Gulf, in Bosnia, and in the FRY, no state has indicated a belief that its extraterritorial actions involved an exercise of jurisdiction within the meaning of Article 1 of the Convention by making a derogation pursuant to Article 15 of the Convention. The third preliminary point that I was... my Lord, I'm sorry.
I'm just looking at paragraph 65, which is worth bearing in mind as well. About the scope of Article 1.
Yes.
And it's not just the travaux préparatoires, they say. It's actually the ordinary meaning of the article as identified by the court. So there's a sort of double branch, double basis for this.
My Lord, yes, that's an entirely fair point. I should have made the link. But 63 and 65 are to be read together is the short point, I think, but my Lord is right.
Well, it's paragraph 17 that deals with effective control.
Yes.
Paragraph 67, and indeed paragraph 62, suggests that Article 1 is its application, the application of the Convention under Article 1 depends upon whether there's an exercise of jurisdiction, which is a rather different thing from saying it depends upon whether there's an exercise of power within the physical jurisdiction.
Oh, yes, I think there are some circumstances in which that has been acknowledged as being correct, but they are recognised as being, as one sees from the detailed analysis of all the previous case law in Alscaney, they're recognised as being exceptional to the essentially territorial nature of it.
Yeah.
So what they're not saying is, if you can show that there is an exercise of jurisdiction, you necessarily fall within. The concept is essentially territorial. That was the basis as analysed in the Alscaney case.
For the obvious reason that things you do within your own country are clearly within your power as a state. But if the underlying conception is whether there is a sufficiently cogent exercise of jurisdiction, that is a slightly different underlying rationale, isn't it?
Well, my submission is that the clear emphasis of both Bankovich and indeed of the majority of my Lord's reasoning in Alscaney is that the key concept is a territorial one.
Yes.
And that if there are certain exceptional circumstances, it is plainly a precondition to those being exceptions that they do involve an exercise of jurisdiction stricto sensu, but the core concept is nevertheless a territorial one.
What does the exercise of jurisdiction mean in that sentence?
In 62.
Sorry, in your sentence, when you said it just now, yes, what did it mean? What does it mean when you say, how does one know when somebody's exercising jurisdiction for this purpose?
Well, my Lord, the answer to that is, I think, by reference to the detailed exceptions that are analysed from the previous case law and that are set out in the Alscaney decision. I mean, there are certain well-recognised exceptions to the essentially territorial nature. I mean, it's not very easy to say. I know my lords, some of my lords at least, had the joy of struggling with trying to find coherence between those various cases. And it's not entirely easy to find a coherent set of principles which bind together all the exceptions. But the reasoning of the House in Alscaney was essentially territorial. Here are some recognised exceptions in the case law, they all involve necessarily an exercise of jurisdiction. But beyond that, it's a bit difficult to find a coherent strand. And moreover, said the House of Lords in Alscaney, we're not entirely convinced that ISA means what it might be thought to say.
What about the last sentence of what is quoted in paragraph 66? You'll see there's a quotation from Söring, and the impression one might get from the last sentence is that the reason for this approach is that the Convention doesn't govern the actions of states not parties to it, which is quite obvious, and running on from that, it doesn't purport to be a means of requiring contracting states to impose convention standards in other states. Now, that might be an exercise of jurisdiction which is ruled out of bounds. But if all you're doing is exercising jurisdiction over persons who actually are nationals of your own state, that kind of objection wouldn't apply, would it?
Well, I don't think that one would, but there are other, and I'm going to come on to difficulties with applying it simply to your own nationals in a moment. I know that's something that my learned friends have made something of, and I've got a bit to say about that.
But it does run through the idea of, well, if you go back to the idea that it's essentially territorial, then if you're looking at what happens within the embassy or the base, or whatever else, you're, at least because you run a boundary around that part of the occupied area in the other state's land, you're not transgressing that last sentence. And I'm just wondering whether that is the sort of root principle, that whatever else a convention it doesn't expand its boundaries outside the limits of what the contracting states can do for themselves without imposing on other states.
Well, that is undoubtedly a theme in the jurisprudence, without any question. There is, I mean, it finds expression in that final sentence of the quote my Lord has identified, and indeed in other passages in the jurisprudence. There is a clear concern not to impose standards on other parts of the world where they don't properly apply, and there is obviously a concern not to end up in a position where there is conflict between two jurisdictions in an unattractive way. It's a theme that I know my Lord Roger was set out at some length in his speech in the Alscaney decision. But my respectful submission, another core controlling feature, and I'll come to this, another core controlling feature is the ability to deliver the rights. It goes to the indivisibility of the rights under the Convention, which is a theme I'm going to come to in a moment. The state does actually have to be able to secure all the rights in the Convention to those who fall within its jurisdiction, and that itself imposes serious practical limitations on the extent to which, as it were, the Convention can be backpack attached to nationals wherever they may be in the world. But I will come back to that in a moment if I may. I'm going to try and identify two or three of the core themes which we respectfully submit one can derive from the speeches of the House in Alscaney, which do touch on and affect the proper approach to the basis for jurisdiction under this provision.
So the mere fact that the United Kingdom, for example, would, I think, exercise jurisdiction in the sense of if a soldier, committed a crime, murdered somebody, that
is not sufficient.
That's an exercise of jurisdiction, but it's not the kind of exercise of jurisdiction which is required.
And that will be my submission. I'm going to make it in more detail in a moment. That will be my submission. It is not enough to turn around and say we found a species of jurisdiction which is exercised by the state over, for example, its nationals by way of long-arm criminal jurisdiction in relation to the most serious offences. It's not enough to say, and it's an impermissible, wrong in principle, we submit, to reason from that proposition, which is accepted, to the proposition that therefore the ECHR applies. We say they're fundamentally different things. The whole conception of jurisdiction under the European Convention of Human Rights involves the proposition that the state is in a position to deliver substantially all the rights and freedoms guaranteed under it to those who fall within its jurisdiction. That, after all, is what Article 1 says.
In a particular place.
In a particular place, it's easier to do. There may be phenomenal difficulties in certain circumstances with trying to do that entirely. But, for example, if you're in the embassy or if you're in a military camp, you've got a base, you've got a physical piece of territory where you can deliver substantially all of those rights. But it is that which is the driving feature, or a driving feature, of the concept of jurisdiction in this convention.
It's the indivisible nature of the convention as part of this too, is it?
My Lord, it is.
Because, I mean, if you talk about for example, the practical limitations, and you think of the provision of equipment for soldiers who are going out from the base on operations, then of course you have the ability to provide them with the ammunition and the protective equipment and everything else. That's not a problem. There's no doubt a logistical problem, but there's no jurisdictional problem in the sense of telling them what they've got to do and make sure they've got it and know how to use it. But you say that's only part of the story. You've got to be able to provide all the rights if you're going to extend Article 1 outside the base or whatever else.
Yes, I mean, if one takes it, again, I don't want to jump too far forward too quickly, but if one takes the proposition forward, suppose for the sake of argument that it was enough that all nationals fell within the jurisdiction. Suppose that was the proposition. The corollary of that would be an obligation on the state to provide, for example, protection to the right to life in the Badlands of Waziristan. It would provide necessarily an obligation, it would impose an obligation on the state to safeguard freedom of expression in the town square in Rangoon. I mean, it would be a very surprising extension if that was the position.
Well, whose freedom of expression are we talking about there? This is the soldiers?
The national. If the premise was the national. So if the proposition is national, we exercise jurisdiction over our nationals for certain purposes, which we do, that in itself is enough to create jurisdiction for the purpose of this convention. The corollary of that would be the obligations on the state to safeguard their freedoms and rights wherever they are in the world.
And to do so would be a breach of the sovereignty of that other country, and therefore one should interpret the convention so as to avoid a breach of international law.
My Lord, yes. In my respectful submission, it would have two objections. The first of them is the one in principle that my Lord identifies, and the second of them is it would impose, in effect, an impossible obligation. So there is a practicality objection as well as an in principle objection. But my Lord is right. The moment you backpack it to all your nationals wherever they may be, then you are inevitably trespassing into territory and sovereign territory of other states, because it follows your nationals around. And there may be certain things, positive obligations, protective obligations, that simply can't be delivered.
But it's not a breach of international law to impose a duty of care in relation to acts abroad if the duty has some relationship, or the parties have some relationship with the state, with the state whose law is being imposed.
My Lord, it isn't, and I accept that. And that is why soldiers in this situation can sue in tort in the United Kingdom.
Yeah.
My Lord is right.
At some point, as I understand it, the argument against you on this point is that the indivisibility requirement only applies where you're talking of territorial control. And at some point, you'll no doubt deal with that.
I'll pick that up. Yeah. I was on my third preliminary point. It's inevitable, I'm afraid. But,
So part 2 was Travo.
2 was Trafo. The third is other instruments.
Right.
And again, if you're in Bankovich, a number of them are set out, perhaps conveniently, at paragraphs 22 to 27. And we draw particular attention to paragraph 25, which sets out the provisions in the 4 Geneva Conventions. And we do so because if the position is, as it is, that this isn't a living instrument for this purpose, and one is therefore focusing on the unchanged meaning from the outset, it is relevant to note, we submit, a comparable set of treaties that would undoubtedly have been at the forefront of the minds of those who framed the ECHR, given the coincidence of time, as between the Geneva Conventions in 1949 and the European Convention in 1950-odd. And you'll see that in relation to the 4 Geneva Conventions, the jurisdictional provision, such as it was that required the contracting states to undertake to respect and to ensure respect for the present convention in all circumstances. So there was no equivalent jurisdictional restraint in those important conventions, which were entered into at pretty much the same time as the ECHR. My lady, from there to back, if I may, to Alscany in the House of Lords, it is, in our respectful submission, the key authority. It analyses Bankovich and its relation to all the case law that had gone before it. And we submit that the reasoning of the House was entirely correct. It recognised Bankovich as what it described, or what's described in the speeches as a watershed authority, which re-evaluated all the previous case law. See the speech of Lord Brown at paragraph 108 and the speech of Lord Roger at paragraph 68. So the authorities before it, before Bankovich, that is, in Strasbourg, are subject to it and are to be read in the light of the Bankovich principles. And the House rejected the core arguments that were mounted in relation to, specifically in particular in relation to the five apart from Mr. Musa, but also in relation to Mr. Musa that had been advanced by the claimants, namely in relation to Mr. Musa, that he was within the jurisdiction, not on the basis of a narrow and tightly circumscribed exception based on an analogy between military prisons and embassies, but rather because he was subject to the authority and control of the British Armed Forces. It was that point which had divided the Divisional Court and the Court of Appeal, and the House of Lords preferred, as flowing from the detail of their analysis of the correct principles, the analysis of the Divisional Court.
So you can just remind me where that is?
See in particular the speech of Lord Brown at paragraphs 128 and 132. Where he refers to there's one other central objection to the creation of the wide base of jurisdiction here contended for by the appellants under rubric control and authority, going beyond that arising out of any narrowly recognised categories already discussed, and yet short of that arising from the effective control of the territory within the Council of Europe area and so on. And then he refers to indivisibility. And then in 132, over the page on 216, just below the letter A, he says, as for the sixth case, I for my part would recognise the United Kingdom's jurisdiction over Mr. Musa only on the narrow basis found established by the Divisional Court, essentially by analogy with the extraterritorial exception made for embassies, an analogy recognised too in Hesse in the United Kingdom. That was about Spandau Prison, which was jointly run by British and Russian forces and held Mr. Hesse. A commission decision in the context of a foreign prison, which had itself referred to the Embassy X in the Federal Republic of Germany. And the core basis of...
So if a soldier is, so to speak, ill-treated on base, he's got an Article 3 complaint. If he's ill-treated out of base, as long as he's not in a military vehicle, he hasn't got a claim.
He hasn't got a claim, and he perhaps wouldn't have a claim even if he was in a military vehicle, which has been the subject of some debate in
Put
other
that
cases
wrinkle
to do
aside.
with...
Likewise, I mean, he's got his Article 10 rights of freedom of speech and opinion, all that sort of stuff on base, but if he's outside base, not so.
Yes. That's the
And
case.
that applies to everybody else who's in the base, whether they're soldiers or British subjects or
Yes.
whatever.
And it applied to Mr. Musa, for example. So that if and to the extent that Mr. Musa was ill-treated outside the base, however shocking and appalling that might be, and Lord Bingham had a thing or two to say about the remedies that would exist in that sort of situation, so there wasn't a vacuum, but however shocking that might be, it would not sound in an ECHR claim. By contrast, if he was on the base, it would. That was indeed the distinction that was being drawn in.
So a base like a consulate or an embassy or a ship or an aircraft is, so to speak, Little England just happens to be abroad.
That's the reasoning. It's a short step by way of analogy from the recognised analogy in Bankovic to do with embassies in particular. And that indeed was the debate that was had, as I understand it, in the House of Lords in Alscany.
Yep.
The core propositions of principle that led to that conclusion are perhaps most conveniently summarised in paragraph 109 in the speech of Lord Brown, which is quite a lengthy paragraph. It contains a series of important propositions, both in relation to the central nature of the jurisdiction, but also in relation to the exceptions to it. Well, I'm not sure if you want me to read the entirety of that paragraph, but it is. I'm very happy to, if you think it would assist those who are listening.
So would 4, just below letter C on page 209, that covers the base, does it? If you establish a base in which you're actually, you've got effective control of a piece of territory.
No.
No?
I'm afraid it's more complicated than that. Yeah, because it then that needs to be read with Proposition 1 and Proposition 2. The essential debate in relation to effective control in the Lords in Alscany was as to whether that concept, effective control of the territory, applied outside what was called the espace juridique, in other words, outside those countries where the ECHR otherwise ran. The particular example of that being Cyprus and Turkey. Those Cypriots who were affected by the Turkish military activities there had previously been able to access the freedoms and rights in the Convention. And the
Which illustration? Where did you put it?
Cyprus and Turkey.
Cyprus, yes, Northern Cyprus.
Yes,
I'm sorry, I thought
exactly.
you said something
No,
different.
Cyprus and Turkey illustrates that
Absolutely.
proposition.
And that's why ISA was such a problem.
That's why ISA, in part, why ISA was such a problem. Lord Roger identified in his speech a number of other reasons why ISA was a problem, not least because of the statement of principle at the end of paragraph 72, which says states shouldn't be allowed to do abroad that which they can't do in their own country. But leave that on one side. So paragraph 109, we say, is a critical paragraph, and it identifies, if I may respectfully say so, 3 core controlling principles. Firstly, that the concept of jurisdiction within the ECHR is essentially territorial. So persons who are on, as it was put in the Travo, the territory of the state concerned, that's the prime rule. That's not merely a general rule or simply a starting point. It is rather, we submit, a central and defining and restraining feature of the concept of jurisdiction in the sense it is used in this particular convention. And Lord Roger, we respectfully submit, correctly described at that point in paragraph 69 of Alscany by referring, as he did, to, quote, the emphasis on the centrality of territorial jurisdiction. First sentence of paragraph 69, with its emphasis on the centrality of territorial jurisdiction, on the regional nature of the Convention, and on the indivisibility of the package of rights in the Convention. The decision has not lacked for critics, and so on. And the point that I was on a moment ago appears from paragraphs 70 to 71 in the speech of Lord Roger, where he then illustrated the reach of the Convention by reference to those factors, by contrasting the sort of airstrike that occurred in Bankovic. If that had occurred in the state's own territory, the result would have been different. Indeed, I think that, to some extent, precedent, paragraphs 70 to 71. There's a case which I think has made its way into the bundle, if not, I'm sure it will be soon, called Padden, Turkey, in which some Iranians were shot from a helicopter by Turkish forces There was a dispute about where precisely they were they in Iran or were they in Turkey at the time. Turkey conceded jurisdiction on the basis, as it asserted, that they'd been shot by the helicopter whilst in Turkey. They asserted they'd been in Iran at the time, but the basis for the Turkish concession was rightly made, so that even if they'd been in Iran, as it were, it would have been very, very similar to the facts of Bankovic, where there was a NATO airstrike into the FRY, a non-ECHR country. By contrast, doesn't matter whether it's an aircraft or anything else, if it's an aircraft that shoots them over the territory of Turkey and kills them, then they're plainly within jurisdiction. So the first point is essentially territorial. The second controlling principle is not in any event outside the espace juridique of the ECHR signatory states. And again, Lord Roger, correctly, we respectfully say, identified this as an important restraining principle. See especially paragraph 77.
How does that differ from the first controlling principle?
The first one is to emphasise that it's essentially territorial, i.e. within the territory of the state itself. So in other words, within the territory of the United Kingdom. And second, if you are going to say effective control of the territory, that has to be within the espace juridique of all the states. So for example, if the United Kingdom, in the unlikely event the United Kingdom invaded France.
Right. So it's taking them together.
Exactly.
Yes, I see.
Well, this is Northern Cyprus, isn't it?
Northern Cyprus, it is. That is right.
I mean, it's North Cyprus, and on the cases there were, I think we gave Transdanisia was another one, and there was one other.
Alaska and Moldova was Transdnistria, wasn't it?
Yes, and then there was a third. Somewhere I made that. I brought them together, but I'm struggling to find where.
Is it Asanidzi?
Asanidzi in Georgia, perhaps?
Yes,
127, is it?
That's the one.
That's the one. Alaska is...
Yes,
Alaska
127, my lord
yes.
is right.
Alaska is perhaps a little different because Alaska involved what was undoubtedly the territory of an ECHR signatory state, namely Moldova. The difficulty in Alaska was that the Moldovans had lost control of a piece of their own territory. So that is a rather different example, but similar, I suppose. But not in any event outside the espace juridique. That's paragraph 77 of Lord Roger's speech, giving the reasons why that is so. See also paragraph 78 for a series of what it might be thought to be compelling reasons for that principle. The essentially regional nature of the Convention is relevant to the way, I'm reading from paragraph 78, to the way the court operates. That court operates, that's the European Court of Human Rights. Its judges elected from all the contracting states, not from anywhere else. The judges purport to interpret and apply the various rights in the Convention in accordance with what they conceive to be the developments in prevailing attitudes in the contracting states. This is obvious from the court's jurisprudence on such matters as the death penalty, sex discrimination, homosexuality and transsexuals. The result is a body of law which may reflect the values of the contracting states, but which most certainly does not reflect those in many other parts of the world. So the idea that the United Kingdom was obliged to secure observance of all the rights and freedoms as interpreted by the European Court in the utterly different society of southern Iraq is manifestly absurd. Hence, as noted in Bankovic, the court has so far recognised jurisdiction based on effective control only in the case of territory which would normally be covered by the Convention. If it went further, the court would run the risk not only of colliding with the jurisdiction of other human rights bodies, but of being accused of human rights imperialism. And similarly, justifying the application and the basis for that principle, see if you would next Lord Brown in paragraph 128. in particular for this purpose, the final sentence of paragraph 128, where he said, bear in mind too the rigour with which the court applies the convention, well exemplified by a series of cases from the conflict zone in the southeastern Turkey, in which the state's difficulties notwithstanding, no dilution has been permitted of the investigative obligations arising under Articles 2 and 3. The point is this: except where a state really does have effective control of the territory, it cannot hope to secure convention rights within that territory. And unless it is within the area of the Council of Europe, it is unlikely in any event to find certain of the convention rights it is bound to secure reconcilable with the customs of the resident population. Indeed, it goes further than that. During the period in question, which is the same period that we're dealing with, here it is common ground that the UK was an occupying power in southern Iraq. See the judgment in the divisional court for the legal regime that applied at that time. Occupying power in southern Iraq and bound as such by Geneva IV and the Hague Regulations. Article 43 of the Hague Regulations provides that the occupant, quote, shall take all the measures in his power to restore and ensure, as far as possible, public order and safety, while respecting, unless absolutely prevented, the laws in force in the country. The appellants argue that occupation within the meaning of the Hague Regulations necessarily involves the occupant having effective control and so on. So a series of other themes there, both in relation to the rigour with which the European Court applies its jurisprudence, and secondly on the practicalities that arise, and thirdly on the potential clashes of principle if one was required to provide and secure all the convention rights and freedoms outside what may be called the little pieces of England that we've referred to.
So, just to follow that point a little further, the indivisibility of the convention is one thing, but also the point that it applies to everyone. So, I mean, it's indivisible both as to subject matter and also to its application as to people. Within whatever you say is the territory, and exactly. So that's all part of the element of control.
It is. But it's a particular species of control. So it's effectively control of the territory for the purpose of being able to deliver to everyone within it the entirety of the rights, is perhaps the best way of putting it. And the third controlling principle is the one my Lord has just mentioned, namely the rights cannot be divided and tailored. And see for that purpose Lord Brown at paragraph 128, the first bit of 128, citing the relevant part of Bankovich at paragraph 40. So those, we say, are the three restraining principles that appear from the Al-Ascani decision. It's right now, you're in Al-Ascani, just to pick up a point of some importance to the Court of Appeal's approach in this case, namely what was meant by paragraph 64 in the speech of Lord Roger. It was an integral part of the Court of Appeal's reasoning that Lord Roger was intending in that paragraph to set out, in effect, a freestanding test for jurisdiction, namely whether or not there was a link between the victim and the contracting state.
Sorry, which paragraph?
Paragraph 64, my Lord. So
this is a word the Court of Appeal has fastened on again and again.
It is. It is. But what they're effectively doing is saying, here's the test. The test is there a link between the victim and the state in question? If there is, pretty much on any basis, if we can establish a link, then that's enough for this purpose. And with respect, we don't understand Lord Roger, said he, putting his head in the lion's mouth, to have intended paragraph 64 to be understood in that way. My Lord, as we understand this, or perhaps I better read it first for those who are listening, it's important, therefore, to recognise that when considering the question of jurisdiction under the Convention, the focus has shifted to the victim, or more precisely to the link between the victim and the contracting state. for the purposes of the extraterritorial effects of Section 6 of the 1998 Act, that's the Human Rights Act, the key question was whether a public authority, in this case the army in Iraq, was within Parliament's legislative grasp when acting outside the United Kingdom. By contrast, for the purposes of deciding whether the Convention applies outside the territory of the United Kingdom, the key question is whether the deceased were linked to the United Kingdom when they were killed. However reprehensible, however contrary to any common understanding of the respect for human rights the alleged conduct of British forces might have been, it had no legal consequences under the Convention unless there was that link and the deceased were within the jurisdiction of the United Kingdom at the time. For only then would the United Kingdom have owed them any obligation in international law to secure their rights under Article 2 of the Convention, and only then would their relatives have had any rights under the 1998 Act. Now, as we understand it, what that passage is doing is to contrast the ECHR with both the Human Rights Act itself and also with the Geneva Convention. Under the Human Rights Act, the focus is on whether the army, as a public authority operating in Iraq, was within Parliament's legislative grasp. Concluded yes, in that case. So although necessary to success for the claimant, that is not, however, sufficient, because he also has to show that he's within the jurisdiction for Article 1 purposes. And the focus there is on the different connection or link, that is, between him, qua victim, and the state. That contrasts, obviously, with the Geneva Convention, where the words are in all circumstances. So no need to surmount any other hurdles under the Geneva Convention. So all Lord Roger is doing, we respectfully submit, is identifying the fact that this link between the victim and the state was required to be focused on as a necessary precondition to Article 1 applying. That explains the last two sentences of paragraph 64, the however sentence and the final sentence. It is not sufficient, it's being said effectively, to point to the conduct of the state, however reprehensible. The requisite link needs to be made out. And that ties in, we respectfully suggest, with the analysis that then follows in Lord Roger's speech at paragraphs 74 to 75.
Well, I think what you find, because I was slightly surprised to see, I thought, I couldn't have just invented this thing, but I mean, if one looks at paragraph 70, the last sentence, there's a reference to paragraph 82 of the Bankovich judgment, which refers to, the court is therefore, in Bankovich, the court is not therefore saying that there was any jurisdictional link between the persons who were victims and so on. It's simply picking that up.
My Lord, we're not for a moment saying that my Lord, as it were, lifted a concept unreferred to in the jurisprudence. All we're saying is that my Lord was not elevating this to a freestanding test. In effect, you were simply identifying the necessity to focus on that link. It wasn't enough simply to say the conduct of the state was ghastly and reprehensible. You need, in addition, to focus on this additional hurdle that you've got to overcome.
It's contrary to international law to legislate without a link, but that doesn't tell you how far the convention goes.
I will put another way, it identifies the necessity of the link, but does not address the content of the required link at all in that paragraph. That's just simply not what it's there to do. The analysis of the content of the link, what type of link is sufficient for the purpose of this, is indeed the stuff of the rest of the judgment. That's what the rest of the analysis is directed towards. So on this basis alone, we respectfully submit, the Court of Appeal have turned into the test, something which simply wasn't designed for that purpose, but was designed rather simply and accurately, we would respectfully submit, to indicate the focus of the inquiry. And we respectfully say that the fact that this was not intended to be the test is clear from the analysis and also the conclusion that follows.
Actually, you can pick the link up. Sorry, I'm using link in another sense, I suppose, in the first sentence of paragraph 65, because having put the proposition as he does in 64, he then says what is meant by, and he's just used the phrase, within their jurisdiction, Article 1 is a question of law, and then he goes on to expand upon that. So I think if you read even those two paragraphs together, you see what's really being intended by this.
Well, my Lord, quite. Happy to take that. 65 can be read with it, but also we would respectfully add, and we'll trying to get the sense of what is intended by 64, it's helpful also to go to paragraphs 74 and 75. Now, in those paragraphs, just to put them in their context, what was being considered at that stage was Issa and Turkey. That analysis starts at paragraph 72. And the critical, or the difficult, one of the difficult sentences in Issa and Turkey is set out in the quote in paragraph 72 of Lord Roger's speech. In particular, the final sentence of that quote said, accountability in such situations stems from the fact that Article 1 of the Convention cannot be interpreted so as to allow a state party to perpetrate violations of the Convention on the territory of another state which it could not perpetrate on its own territory. And in short, the analysis that then followed indicated that that wasn't actually what Bankovic was about at all. And in particular, when Lord Roger comes to deal with that concept in paragraph 74...
What wasn't what Issa was about, is that right?
Wasn't
what Bankovic was about, wasn't what Issa...
It was what they said that in Issa.
Yes, but it wasn't what Issa was about.
No, it wasn't.
No.
It wasn't on the facts what Issa was about. But the question is, was that consistent with Bankovic?
Yeah.
That was the analysis which followed. Was that consistent with Bankovic? And the answer was no. See paragraphs 74 and 75. And one of the reasons why that sentence was problematic as a basis for jurisdiction appears from the second sentence of paragraph 75. Moreover, says Lord Roger, the proposition appears to focus on the activity of the contracting state rather than on the requirement that the victim should be within its jurisdiction. So again, we're on to focus. But all of that analysis helps to indicate, in my respectful submission, that paragraph 64 is not intended as a freestanding test, so that one can simply, as it were, stand back and say, is there a link? What are the links? If there are sufficient, in my judgment, against some standard, then that's it. So, my lords, that's what we say about the three core restraining principles and paragraph 64. Then right to focus on the exceptions to the essentially territorial nature of the jurisdiction. And my submission is that soldiers generally outside the jurisdiction are not within any of them. They must be, it must be an analysis by analogy, if it's anything at all, and I've made my submissions that the moment one's in that territory, perhaps even if one's in that territory, that attracts the precautionary principle I mentioned at the outset. But considerable play has been made, or emphasis has been placed on the possibility of jurisdiction being attached to nationality. We've to some extent touched on this already in the exchanges this afternoon, but just to focus specifically on the relevance of nationality as a head in the argument.
You mentioned analogy. The question is analogy with what? The analogy that the Court of Appeals was analogy between a soldier within the camp and the same soldier outside the camp. That was very much their thinking. Why distinguish between the two?
My lord, yes.
The answer might be that the reason why the soldier within the camp is within the protection is because he's within the camp.
Quite.
And not because he's a soldier.
Quite. My lord, that will be my submission. I'm going to come to the difficulties of inside and outside base. I mean, it does to some extent cause a problem. If you draw jurisdictional lines territorially, in any shape or form, you will inevitably, as it were, set a hard-edged line, and you will inevitably have these difficulties of persons who are within or without. But the basic reasoning for why someone within is within the jurisdiction is, as my lord indicates, simply because he's within. And in those circumstances, the state is in a position to secure all the rights and freedoms in a way that he isn't outside. But nationality has been focused on. It's right I should touch, however, briefly on
I'm sorry, I mean, why has it got to be with analogy with some existing exception? I mean, the basic proposition for which Bankovic stands is it's essentially territorial. Other bases of jurisdiction have to be exceptional. And then it deals with a series of exceptional circumstances. And let's assume you're right in saying this isn't one of them. I mean, that still leaves, at least theoretically, open for play, does it not, the proposition that there should be another exceptional category, namely servicemen abroad, when they are so totally, so to speak, within the framework of UK law, discipline, etc., etc., etc. I mean, I'm not saying it's right or it's wrong, but I mean, why isn't that still there to play for? Why is it absolutely essential for the appellant, for the respondents to bring the case within an existing recognised exception to the general proposition?
Well, my lord, I'm not entirely closing the door on the possibility that there might be other exceptional bases that haven't yet been identified. But you will appreciate that the thrust of my submissions is that this is a territorially focused, for good reason, convention and jurisdictional concept. And the courts in Strasbourg and the courts over here, over a number of years, have developed a number of well-recognised exceptions to that. And in my submission, one does need to be extraordinarily cautious, if I can put it that way, without entirely closing the door on the exceptional category that my lord raises. One needs to be exceptionally cautious before seeking to expand it out. Now, normally the way in which caution is exercised is by recognising that the court has, in Strasbourg, recognised certain exceptional situations, and then reasoning, as it were, incrementally by way of short steps from that. That, in my submission, is an appropriate, cautious approach to this sort of concept and this sort of exercise, rather than simply saying, as the Court of Appeal appears to have done, is there a link? Link is the test. Let's look at all the factors that create a link. As a matter of common sense, you're within. My submission, that's a dangerous and unprincipled basis on which to expand out what is and properly should be a tightly focused concept of essentially based on territory.
Another way of putting it, would it be that to be principled, any of these extensions must start from the principle of territoriality and say that in these circumstances you can view it as being in some sense a notional or constructive form of territorial jurisdiction. But the notion that any single British national anywhere in the world was carrying a bit of Britain around with him would be several steps too far.
My lord, I would go with that, with one note of caution, perhaps against myself, as it were. There are some categories of exception that my lord will have seen where it's rather more difficult to say in relation to that recognised species of exception. Well, it's as it were essentially a little piece of whatever state it is outside. And there are cases like Ochelan and so on, where state agents are putting people onto planes, and that's very hard to tie directly back into the sort of territorial approach that my lord has indicated. But as an essential approach, I would accept that, subject to that caveat. There has been some recognition, at least in relation to that tight group of cases, such as Ochelan, which deal with extraordinary extradition, if one can put it that way.
Why should one not contemplate a type of application of the Convention which depends upon personal control? I mean, the idea of territorial jurisdiction is that you have complete control over people within it, over the territory. Now, in the case of the factors which the Court of Appeal identified, leave aside their reasoning of link, but they identified the factors in paragraph 29 of their judgment, and they are essentially the personal and legal control which a government has over its serving soldiers wherever they are. That is a very tight link, and it's not a territorial one, but it does have its own particular features, and I think the issue in this case is whether that shouldn't suffice.
My lord, I'm going to come to that. I will give you an answer to that, which is that the difficulty with that approach is that it pays scant regard to the need on states, the corollary, which is the obligation to secure all rights and freedoms under the Convention to those within your jurisdiction.
And possibly the need to respect other people's jurisdiction as well.
Exactly.
But, I mean, one would need to be persuaded that those are real problems in the present type of case, wouldn't one? I mean, I know one runs into the danger of the argument that one's tailoring the Convention rights, but the reality in the present case is that there wouldn't be any problem about recognising a Convention duty.
Well, my lord, there might be a very considerable problem with recognising a Convention obligation to secure all the rights and freedoms to soldiers by virtue of their status as soldiers, which flow from all the features that my lord has identified, the Court of Appeal identified, the degree of authority and control, jurisdiction, military jurisdiction over them, and so on. There would be a very considerable problem saying that by virtue of their status as soldiers, they are within the jurisdiction of the United Kingdom, because that would be to backpack, as it were, the ECHR onto the status of soldier. Well, I'm going to come to that, because what I was proposing to do was to go first to nationals, then to diplomatic agents, and then to soldiers, because that, as it were, may illustrate the difficulties along the way. But that's the short answer to my lord's point. And in relation to nationality, my first submission is that it does need to be clearly recognised that the nature of the concept of jurisdiction in Article 1 is a unique one. It's unique to the ECHR. Its meaning and scope is to be determined in the manner set out by the European Court in Bankovich and by the House of Lords in Alskany, and so by reference to the controlling principles that I've identified: essentially territorial, essentially regional, indivisible. And the fact that a state, for some other purposes, exercises jurisdiction in a narrower sense or senses, such as long-arm criminal jurisdiction, does little or nothing in my submission to assist in that analysis. And I've made the submission already, but I repeat it. It is wrong in principle, we respectfully submit, to assert that merely because there is a specific and possibly narrow basis for extraterritorial jurisdiction that is recognised as legitimate in international law, that means that anyone within that aspect, or an aspect of that exercise of jurisdiction, falls within it for ECHR purposes. Take long-arm criminal jurisdiction. That involves a limited exercise of a different type of jurisdiction. It's not an exclusive jurisdiction, and the UK only asserts it in any event in respect to a few of the most serious criminal offences. But more importantly, that approach to simply say, well, they're in the jurisdiction under international law for certain purposes, therefore ECHR jurisdiction must follow, does not pay any heed, in my respectful submission, to the centrality of the territorial and regional restraints within the ECHR concept of jurisdiction.
I mean, it would also have a very strange effect because, I mean, different countries and different legal systems assert jurisdiction in completely different ways. Civil law countries, I think, certainly traditionally, have had much more regard to personal jurisdiction. They're citizens of France and so on and so forth. So, and that would result in if one applied that approach, that would tend to result in
a disparity as between those subject to the Convention.
A
common principle.
A single.
My lord, I respectfully agree with that.
Idea.
But it leads to the additional problems if one simply adopts that approach, which is that it doesn't really tell you anything if you say, well, you're subject to long-arm criminal jurisdiction, or you're subject to the military discipline, you're subject to the authority and control of the British state. It doesn't tell you anything about whether all the rights can in fact be secured, either practically or in principle. See, for example, the reference in the speech of Lord Brown to the Hague regulations and the difficulties that they would have imposed in the specific context with which we're dealing, namely the need to respect, so far as one was able to, local traditions, customs and laws, in effect. So my submission is that for all those reasons, the obligation on the state to secure all the rights and freedoms in the Convention does not follow nationals about the world attached to them because of their status as nationals.
I mean, there is, I just raise it because I think it is relevant in this context. I mean, there is some dilution of that concept of not tailoring, whatever the phrase is, in the, what's it called, the Ilascu case. I mean, there was a dissent by Judge Bratzer for some, but the majority, it's true that was Council of Europe country, it's true that both Russia and Moldova had some, so to speak, governmental control, but the majority of the court in that case said that Moldova, although it wasn't able to guarantee all the rights, had to guarantee those which it was in effect capable of giving effect.
My Lord, it did, and I accept that. And to some extent, of course, that therefore exists, as it were, as a tight and narrow exception in the specific circumstances that were being dealt with in that case, which was effectively losing control of part of your territory.
Right.
Non sequitur, that you then reason from that proposition to say, well, as a general proposition, it doesn't really matter elsewhere.
No.
You can just forget about indivisibility and put it in your backpack as a national and take it around the world with you. It was a very specific situation where the state still, as it were, was sovereign over its own territory, but had serious practical problems of implementation because there were rebels in place and they couldn't get in there. And so the debate in that case was, well, does that mean the other way, that they don't have to do anything? Answer, perhaps unsurprisingly, no, they've got to do what they can. But one can't reason, in my respectful submission, from that proposition to the proposition that says, well, let's forget about indivisibility.
No, you can't reason from it. I mean, but you can invoke it and say, well, there is an exception to it. Create me as a new category exceptional to the broad territorial requirement, and that's another exception to the otherwise important principle of indivisibility.
In principle, one could go down that route of reasoning, but the difficulty that one runs into, certainly in relation to nationals, are all the difficulties I've just identified. I mean, firstly, there's no authority that states that just because you're a national...
Well, it wouldn't just because you're a national. I'm sorry, so you're still just
I'm still on nationals. I'm going to come to
national.
soldiers in a moment.
Yes.
There are other things which apply to soldiers, but just stick with nationals for a moment. Just because you're a national, that status itself brings you within the jurisdiction for all purposes, because if that is so, and perhaps the clearest example, I've mentioned it already, but perhaps the clearest way of illustrating that is, assume for the sake of argument that you were able to reason in that way. You're able to say, well, there's Alaska, it shows you can tailor them a bit. In the context of nationals, tailor them for nationals. All right, that means that you can't do it all the time, but it wouldn't just mean that. If one thinks for a moment about what it would mean, the mere status as a national attaches, as it were, the ECHR obligation. That would mean that a state would have to seek to protect, in an Osman, a classic Osman situation, in relation to a British tourist, for example, in Pakistan or Afghanistan.
Seems to be quite contrary to the way the thing works within, undoubtedly, the jurisdiction we're in just now. Because the duties are not owed to nationals. Everyone.
They're owed to everyone on the territory.
And if you're invoking the convention, the first thing you do is point to Article 1 and say, I'm somebody
on the territory.
On the territory, and
So
therefore
right.
everybody, I'm just one of everybody. There's no distinction between what I do or what I am or what my nationality is or whatever else. It's just simply because I'm here and I'm entitled to the protections. And the problem of trying to divide it up on a personal basis is that you run counter to everything that anchors the rule that everybody benefits under the
Within your own
convention, wherever
jurisdiction,
they are, so
your
long as
own
they're
territory.
within the jurisdiction.
Oh, yes, I accept that point.
But I think, nationals, it doesn't really help as an example, does it? Because it's such an extreme and obvious situation.
Well, my Lord, let's go to a slightly less extreme one, and down the funnel, as it were. What about diplomatic agents?
Yes,
And judges abroad? Drods.
Drods.
That's the next lot. And here, in a nutshell, the Court of Appeal's reasoning appeared to be, well, those people, or people of that type, bring third parties within the jurisdiction for certain purposes. So if the judge is exercising jurisdiction in Andorra or wherever it was in Rhodes, that can bring third parties within the jurisdiction for those purposes. So went the reasoning of the Court of Appeal. It must follow that they themselves, the diplomatic agent or the judge, is within the jurisdiction. And that, in my respectful submission, is is a strange and difficult piece of reasoning, to reason back from the proposition that because you as a state agent can, in certain very limited circumstances, such as Drodds, bring third parties within the jurisdiction, that you yourself are for all purposes within the jurisdiction of the state. In my respectful submission, the difficulty with that is first, that they are focusing those cases on something entirely different, namely whether the specific types of state agent can, in certain limited circumstances, engage the responsibility of the state by bringing others, third parties, within the jurisdiction. And we respectfully agree with the analysis of Lord Brown at paragraph 109, which we've been to on a few occasions now, but 109.4 Roman 3, he said that Drodds is the only authority specifically referred to in Bankovich as exemplifying this class of exception. Drodds, however, contemplated no more than that if a French judge exercised jurisdiction extraterritorially in Andorra in his capacity as a French judge, then anyone complaining of a violation of his convention rights by that judge would be regarded as being within France's jurisdiction.
Almost a kind of estoppel concept. It's almost like an estoppel contest. If you assert jurisdiction, you can't complain if somebody complains about the way you've exercised it.
Exactly. But and that may be what underlies the limitation of the principle to be derived from Drodds, but we rely more generally on the fact that it is a limited principle to be, and correctly limited principle to be derived from Drodds. Drodds is not authority for the proposition that all judges exercising jurisdiction abroad are themselves within the jurisdiction of the state which sent them.
The jurisdiction is used in two completely different senses, isn't it?
My lord, it would be if that was the position. I mean, they're exercising the jurisdiction of the state over third parties, and you're reasoning from that species of jurisdiction to saying, as you rightly say, some completely different exercise of jurisdiction by the state.
The difficulty I have with Drodds is that this is all based on a very general statement in paragraph 91 of Drodds, which refers to a whole host of previous admissibility decisions. One has very little clue, actually, whether in context the statement has anything to do with this type of case at all. I'm not quite sure what sort of situation they are contemplating. How could a French judge exercise jurisdiction extraterritorially in Andorra in his capacity as a French judge? I suppose, I mean, it's not what the facts were in Drodds. I suppose one contemplates there might be, some international agreement to that effect?
I think that's right.
But on behalf of France, it doesn't make much...
No, I think on behalf of France, 121 I'm being referred to, which may provide the answer. In Alscani, paragraph 121.
I mean, do you know what the cases referred to in paragraph 91 are about? Have we got them?
Yes, they are... I think they may be the ones referred to at paragraph 121 of Alscani, but we can check.
I'm just trying to see where Drodds is referred to in Bankovich, because that, so I point out the only illustration of this category given there. I'm just looking in Bankovich. Can anybody find reference to Drodds in Bankovich?
I think Jean-Pion was one of them, and that involved running schools in Algeria, French schools in Algeria, by specific treaty arrangements.
Yes.
I'm just checking whether...
Drodds is a rather unusual case because Andorra, according to paragraph 34 of the judgment, was ruled by two co-princes, the President of the French Republic and the Bishop of Urgell. So this was a classic case of French partial sovereignty.
69 of Bankovich is the
Thank you very much. There you go.
I think it wasn't a case of French sovereignty because the President of the Republic was the successor entitled to the King of France, who was the successor entitled to the Comte de Foix. Who...
Oh, in which case you're somewhere ahead of them. I'm sure that's right. So, my lords, we say that neither Drod's nor the diplomatic agent's references indicate that that people holding that status, whether as a judge exercising jurisdiction outside his own territory or diplomatic agents more generally, are within the jurisdiction of the state which sent them, as it were. Oh, I'm sorry.
So could France have secured all the rights in Andorra's territory?
Well, I don't think it could, which is why it stands as an exception to the principle. And it's difficult to see how they could have exercised jurisdiction over that sovereign territory, or split sovereign territory for all purposes. I don't think anyone was suggesting in Drod's that they could exercise...
So what were they suggesting? It was Article 6, clearly.
Simply that it was Article 6, that if your judge was exercising Article 6, purporting to give people a fair trial, then he could hardly complain if someone complained about their fair trial guarantees being breached.
I always find it quite helpful to think of Article 12 when we're having this sort of discussion. That's the right to marry.
Yes.
And whether it would be possible to secure that. Because most of the others, you've got either they're very extreme with Articles 2 or 3, or else you've got qualifications which may get over some of the hurdles. But Article 12, could you secure to a British soldier serving in Iraq, even if he was off base, the right to marry in reasonable circumstances? The answer might be yes, of course you could. I'm not saying that's what my answer is. Please forgive me. I just find it a useful one when we're looking at the whole of the Convention rights. And it backs up your point about Drod's. France wouldn't have been able to secure that its judges could marry in Andorra.
Yes.
It draws a bit of a red herring. If you go to paragraph 69 of Bankovitz, I mean, it didn't even work there. In that case, the impugned act could not, in the circumstances, be attributed to the respondent states because the judges weren't acting in their capacity as French or Spanish judges.
Well, I mean, that's the whole point about Drod's.
Yeah.
It's all obiter because it doesn't arise.
I know. I mean, all I did was select it as the one case which, you know, even theoretically was instanced for this particular
It's paragraph 69.
category of exception.
69.
Yes. But may not even go that far, as a short point. I mean, all of that makes it doubly difficult to reason back, as it were, from the fact that in certain circumstances, even if correct, they can bring third parties into the jurisdiction to say, therefore, they are themselves within the jurisdiction. And certainly authority, again, come back to the precautionary approach, authority does not indicate, still less state, that these types of person are, by reason of their status, diplomatic agents, judges operating abroad, by reason of that status, within the jurisdiction. And nor would that, we respectfully submit, be appropriate in principle. One should be properly cautious in extrapolating from one category to another. And there are similar objections, if it's based on that sort of status, to the objections that apply in the context of nationals. If it flows simply from status, why doesn't the ECHR therefore follow them in a backpack around the world? And if it does, whither, it might be asked, the territorial centrality, and how can they be enforced? And whither the careful analysis of the House of Lords in Alscaney. Moreover, it might be thought that if that was the position in relation to this status of person, you would be creating a potentially enormously broad approach. I mean, if it applies to diplomatic agents, just because they're diplomatic agents, they are therefore within the jurisdiction. If it applies to them, why not, for example, to everyone in Crown employ? What about policemen abroad? doctors employed by the National Health Service abroad? Why aren't they within the jurisdiction by the same process of reasoning? The state exercises some form of authority and control over them, therefore they're within the jurisdiction because they can bring others within theirs. If that reasoning works, it is potentially extraordinarily broad and does raise, directly and unaddressed, we respectfully say, by the Court of Appeal, the question of these other categories.
Just as it's a while since I read Droz, if I ever read it at all properly, but do I understand that in fact the court held that it did not have any jurisdiction to deal with the Article 6 thing because the acts of these judges were not to be attributed to France?
Correct. Correct.
But it did have jurisdiction to deal with Article 5 because the detention had occurred in France.
Yes, correct. I think we're operating on the basis that even if that wasn't right, and even if they'd reached a different judgment, namely to say that if you're acting abroad as a judge and you can bind your state, and Article 6 is there, can one reason back even from that point, even assuming that, can one reason back to say, well, because they can bring them within the jurisdiction of the state which sent them for that purpose, it necessarily follows that they are within the jurisdiction of the state which sent them. But my Lord is right on in terms of the facts and the resolution in Droz. They didn't even pass first base, as it were.
They upheld the objection.
Droz is really significant for what was not decided, but the obiter statements.
Yes.
I.e. there was a heading dealing with objection of lack of jurisdiction, ratione personae, and all the argument was on the basis that this was something that could exist, although on the facts it didn't.
Yes. Yeah. And what we have to confront is whether or not, as a species of reasoning, you can take it that stage further. Yes. I've said it on a number of occasions now, but whether you can reason back from that to say just because you can bring third parties within, it follows that you yourself are within for all purposes. And we have essentially the similar difficulties to the difficulties we had with nationals, but perhaps with added features here, because it forces you to confront what degree of authority and control. It forces you to ask the question about policemen abroad, or doctors abroad, or whoever it may be abroad, Crown employees.
Who are these doctors abroad? I'm sorry, I didn't know the NHS had doctors abroad. Who are they?
Well, I don't know whether they do or not, but I'm positing an example of a Crown employee, who is sent abroad for a particular purpose. I don't know, an NHS doctor sent abroad to Haiti to help with the relief effort. Is the fact that, or a policeman who's sent to Haiti to help with the control and so on of the aftermath of that.
There are certainly doctors who go out to Afghanistan, who are members of the National Health Service, who go out there. I've seen them on television. There's a scheme for them doing exactly that.
Yes. I don't know precisely on what basis.
I think they volunteer, but I mean, they're obviously encouraged.
Oh, Médecins Sans Frontières.
Quite. Well, it caused hilarity when I said I had no idea whether there were such people, but it's not difficult to imagine that there might be, precisely on what basis they go on. And so to soldiers, I mean, they are undoubtedly subject to the authority and control of the state when they are abroad. See especially for all the ways in which that authority and control is exercised, Lord Bingham in Alscaney at paragraph 26, which refers to disciplinary and criminal military discipline, to some species of long-arm jurisdiction in relation to their conduct, to the fact that they can see and talk and so on. So they are, we fully accept, subject to the jurisdiction, to use the word, of the United Kingdom for a whole variety of different purposes. But that does not, we respectfully submit, answer or really assist on the question, are they within the jurisdiction applying the approach set out by the House of Lords in Alscaney? The objections and the difficulties that I've identified in relation to nationals and in relation to, for example, diplomatic agents, apply equally to them. in particular, we respectfully submit, a mere link, in inverted commas, in the general sense, applying common sense, whatever that means, is not enough. And the Court of Appeal, we respectfully submit, wrongly elevated that to the test. But the application to them of the ECHR as a matter of status, in effect, we submit, severs the link with the territoriality principle. That alone makes it suspect. But the factors which led to the core principles of restraint identified by the House of Lords in Alscaney, we submit, operate here, including, for example, practicality of enforcement, difficulties of protecting them in the bad lands of Waziristan, difficulties of the ECHR simply following them around, even as soldiers, into the marketplace in Rangoon or elsewhere.
I'm sorry, what's that difficulty?
Why are you bringing Rangoon into it? It's
Well,
confusing all of us. It's a long, long time ago, Mr. Eden.
You can take, I entirely take that point. I was trying to posit examples of places where, in common minds such as my own, the prospect of freedom of expression might be perceived as being not necessarily entirely easy to enforce. But one can posit a whole series of different examples. The short and general point is you would have to protect them by virtue of their status through the application of the positive obligations in a series of places which it might be extraordinarily difficult, would be practically impossible to comply with the obligation, and would involve the difficulties of principle of abutting up against another country's sovereignty.
So you're not just talking about the problems of provision of equipment there, are you?
I'm talking generally about the protection of their rights outside the little piece of England, outside the place where those rights can be secured.
But unless there's a problem with sovereignty, and possibly, so to speak, customs such as theirs under the Hague regulations, you have to observe. I mean, where's the difference from Belfast 10 years ago? That's the point made against you.
Well, Belfast 10 years ago is within the jurisdiction of the United Kingdom.
No, of course it was. But where's the difference in terms of the practicalities?
Well, my lord, there may be very little difference in that example, but what would have to be secured to them are all the rights in all places. That's the difficulty with it.
Well, I mean, there's no greater difficulty in getting married, presumably, if you're in Baghdad than if you're stationed in Belfast, is there? I don't know. I mean, it might take longer. You might have to have a longer engagement with, etc., etc. But I mean, you know, what are these big differences?
Well,
this would help to crystallise them.
If the ECHR applied to soldiers because they are subject to the authority and control of the United Kingdom in the variety of ways identified by Lord Bingham, then it follows that the ECHR goes with them wherever they may go. And that would mean, for example, that the United Kingdom would have to seek to protect their rights in whatever territory they happen to be.
Exactly, as in Belfast. And where, I mean, just crystallise the crunch distinctions between Baghdad or Basra and Belfast in terms of the difficulty of achieving it.
Well, there may be a series of difficulties. Whatever difficulties flow from local law. There may be not much difficulty or difference in terms of active combat on the streets of Belfast and active combat on the streets of Basra. But what, for example, if, I don't know, local law allowed you only to marry in an Islamic ceremony? What if there were very strict local laws controlling freedom of speech which would be allowed in this country?
Well, marriage you could get round by having your own marriage laws allowing people to get married in exceptional circumstances, which indeed we have.
Well,
which is part of, I think, what my lord is thinking about.
My lady, yes, but well,
you can secure the right to do it, other than by securing the right to get married in a place outside the base or a place covered by local law.
Well, one would have to secure everything. One has to secure all the rights. It has to be Article 8, Article 10.
Yes, the qualified rights, you bring in the qualification, but they would virtually extinguish in some instances the right. And Article 8 is a fairly amorphous right, but one can think of all sorts of Article 8 examples that you certainly would not be able to ensure were available to your troops
I'm having great difficulty hearing. I don't know if there's any way of putting the microphone up at all.
Sorry.
He didn't
I
hear.
think the point my Lord Phillips was making was that there were perhaps a series of examples under Article 8 in relation to which there would be extraordinary difficulties in seeking to protect the rights of soldiers in various different parts of the world, off base.
I thought there was some inhibition about enjoyment of Article 8 rights in Belfast, but maybe not, I don't know.
Yes, I'd certainly welcome some examples, practical examples, where it would make a difference whether it was Basra or Baghdad.
My Lord, perhaps a sensible thing would be for us to try and work out a couple of examples or a few examples overnight of.
And for my part, I think it would also help if you looked at the authorities in paragraph 91 of Droz, because, I mean, I've looked
Where
at
is Droz?
it is tab 61 in volume 7. A couple of them are in our bundles. I've looked at the two. Cyprus and Turkey is, you would, I think, deal with quite easily because Turkey took over northern Cyprus completely. But X and Y versus Switzerland is interesting because the Swiss authorities, under agreement with Liechtenstein, were operating the Liechtenstein border control. And this gentleman who had two illegitimate children in Liechtenstein and spent more time there than he should have done, brought proceedings against the Swiss authorities because they had, I think, arrested him for exceeding his permit to stay. And he said, I've got family and health reasons for being in Liechtenstein. He was ill. And they're in breach of the convention. And the reasoning of the admissibility decision is that the convention applied in respect of the immigration activities of Switzerland in Liechtenstein. And Switzerland can't have been obliged to supply all convention rights in Liechtenstein. Their authority was simply limited to immigration. So I think the case looks to be against you on the tailoring argument. But I mean, I don't know what the other cases decide, and it would be interesting to see.
Which paragraph in
This is paragraph 91.
Yeah. We can,
The case we've got of X and Y in Switzerland is in bundle 12, tab 103.
we'll dig them out and make them available.
But it's slightly similar to this case in a way, I mean, except that the authority to be in Iraq is presumably United Nations authority at the relevant time, Security Council.
My Lord, I don't know whether that would be a convenient...
Yes, certainly. We will adjourn until 10 o'clock tomorrow morning.
My Lord, I'm so sorry. Did you mean 10, are we 10 o'clock tomorrow morning or 10:30?
10 o'clock, aren't we?
What?
Yes.
I think we are 10 o'clock. We're sitting rather longer. Today. Are we?
Here we are.